Your paper. Your paper's due a week from right now. I'm sure you've been through the first draft with your editor and ready to fine-tune it. Some of you have had a few questions about what in the world should I do? How can I predict how the Supreme Court would come out? Obviously, there's no right answer because nobody knows. It hasn't happened yet. But your assignment is to assume that the panel decision of the Ninth Circuit was the decision of the Ninth Circuit that the losing party took to the Supreme Court of the United States on petition for certiorari. And what you report in your news article is, yesterday the Supreme Court decided that something, one way or the other, in favor of minority television project, so that commercials of particular kinds are allowed on public radio and television, or in favor of the FCC upholding the statutes that prohibit public stations from airing commercials of almost any kind, so on. Be sure to address the prompt, the points in the prompt. Report what the case was about, the key facts in the case, what the government contended on one side, what minority TV contended on the other side, and how the case was decided. What the majority of the Supreme Court, you've got a clean slate to write on here, decided and why they decided it, and whether there was a dissent. Maybe you decide that the case was decided unanimously. Sort of a cop-out, because it's unlikely that, given the contentious issues here and the way that they can be cut up, diced in many different ways, unlikely that they would all see the case the same way. So, you get some credit for plausibility, and in the same way as when you say that the majority opinion was joined by Justices X, Y, and Z, it ought to be sort of plausible that that's the way those particular justices would go, now that you're fully conversant with who the people are in the Supreme Court and their approach, at least, to First Amendment issues. You ought to have some sense of which way they might go. What else can I tell you? Cool. What each justice would say? Well, not each justice. It's highly unlikely that each justice would write an opinion. I mean, I can only think of one case in which that occurred, the Pentagon Papers case. I mean, there will be a majority opinion. There may be a concurring opinion. Who knows what justices will join in that? There may be a dissent. Who knows what justice? But each justice doesn't write an opinion. So we don't know what each justice will say. What else? Okay, good. You're in good shape. Today, you get to make fun of me. The issue before us is not the extent to which the Supreme Court protects speech and press against government regulation. Rather, the issue is the extent to which the First Amendment can be used not as a shield to fend off what government wants to suppress, but rather used as a sword to achieve access to information that the public ought to know about. Or put it another way, can government cut off information at its source so that the people don't get to learn what it is? And the issue first arose, that is, the gut issue here, whether there's any such thing as a First Amendment right of access to government information, really didn't arise until the early 70s in the Watergate era, where investigative reporting started to take off, where reporters, instead of sort of passively receiving press releases and rewriting them for public consumption, started to dig into what government was really up to, or corporations and private entities too, but not accepting at face value what the president's spokespeople would say at press conferences, but digging into it. And they would frequently encounter, no, I'm not going to tell you that, or no, you can't come in. And that's what raised the issue about whether reporters, we're in that business after all, but all of us, whether we have any First Amendment enabled ability to get information out of government about it, what it's really up to. The general rule, of course, about whether reporters can go places that the rest of us can't is that it's the same access to places for both reporters and members of the general public. That is, reporters don't have any special exalted status that allows them to go places, to trespass on private property, to go into government buildings. So they don't have any greater right than all of us have as members of the general public. But that means that the press, actively engaged in investigative reporting, is barred from doing its job when government says no. And that raised the question of whether the First Amendment recognizes something sometimes called press exceptionalism, where the press has rights that members of the general public don't have, emphasizing that the press is explicitly recognized in the First Amendment as having a freedom that may or may not be different from the freedom of speech that we all have. And the access issue first arose in the early 70s with regard to access to prisons. And the way that it came up was that in the early 70s, late 60s, early 70s, there was increasing public concern and attention to conditions in prisons. And prisoners began to raise civil rights type claims, the way the civil rights movement had raised fundamental issues during the 1960s. In the early 70s, there was a prisoners' rights movement. And sort of one of the issues was, does this most despised minority in our society, prisoners, have any constitutional rights? And the courts had traditionally taken what they call a hands-off attitude toward prisoner claims that prisoners' constitutional rights had been violated. Hands-off in the sense that the courts won't enter this thicket at all, that decisions about how to treat prisoners are properly given over by our system to the professionals, the wardens and the jailers who run the joints, and the courts shouldn't be second-guessing them. a few chinks in that facade started to show up in the late 60s. A couple of the cases were brought by black Muslim prisoners who terrified prison officials because of their cohesiveness, their discipline, their militancy, and they insisted that they had a First Amendment right to worship in prison. And many of the prison officials would not allow them to gather for any kind of services. And so the suits were brought, a couple of them percolated up to the Supreme Court, which indicated that prisoners do have some First Amendment rights. They were religious rights, the right to freedom of worship. So there were a few early indications, but by and large, it was on the margin of acceptability for prisoners to have any kind of rights, including free speech and freedom of the press. Amongst the prisoners in the early 70s were a number of radical political prisoners, including people like George Jackson in California, who was a celebrity prisoner. He was accused of murdering, along with others, accused of murdering a guard at Soledad Prison down in the valley, was transferred up to San Quentin. And he was an extremely charismatic, articulate man who articulated the grievances that prisoners had against the prison system and acquired a following. What became what the prison officials called a big wheel, who commanded a following of prisoners and correspondingly frightened the guards who had to keep him in check and so on to make sure that he wasn't running the prison rather than they. He wrote, he was a good writer. He attracted the attention of many outside journalists, including Eve Pell, who was involved in the prisoners' rights movement, wrote a lot about it. And she wanted to interview George Jackson while he was at San Quentin, only to find that the California prison system had adopted a regulation, a rule, that prohibited journalists from singling out individual prisoners for interviews. They were allowed to go into, reporters would be allowed to go into prisons. You could call up and make an appointment with the warden's office to go into a prison. You might be able to, if you were a photographer or a television reporter, take in your cameras, take pictures of people. You could talk to prisoners that you might randomly encounter around the prison, but you couldn't single out an individual prisoner for interviews under this California rule. The same phenomenon was happening in the federal prison system, where there were political-type prisoners who were becoming celebrities, big wheels, and the prison officials wanted to shut them down. And so the federal prison officials adopted basically the same kind of rule that California had that prohibited reporters from singling out individual prisoners for interviews. Eve Pell and the Washington Post, on the California level and the federal level, both sued in prison systems, challenging the constitutionality of this rule under the First Amendment, claiming that the prisons interfered with, denied the reporters and the prisoners their First Amendment rights to communicate information that might ultimately inform the public about what's going on in prisons. The two cases were decided together, Pell and Saxby. Pell was Eve Pell. Procunier was then the director of the California prison system. The Washington Post sued Saxby, who was one of President Nixon's attorneys general. The attorney general is nominally in charge of the federal prison system. And the Supreme Court decided against the reporters and prisoners in a 5-4 decision, opinion written by Justice Potter Stewart. And his opinion emphasized that the rules were not an attempt to conceal conditions in the prisons. It pointed out that access to the prisons was relatively open, in the sense that reporters could get in and report about what they saw. But the majority bought the prison's argument that allowing individual interviews of prisoners would potentially create security problems for the prisons, and that trumped anybody's First Amendment right, the court said. There was a dissent, surprisingly, by Justice Lewis Powell, who was a Nixon appointee and a relatively conservative man, who thought that these rules, the prison rules that across the board prohibited individual interviews, was too much of a blunderbuss, too crude an instrument. And it was applied even in cases where there was no reasonable likelihood that there would be any prison security problem if the interview took place. So he thought that a much narrower rule would be constitutional, but there shouldn't be an across-the-board prohibition. He emphasized that the press acts as the eyes and ears of the general public, and therefore there's good reason to allow reporters to interview individual prisoners, whereas where the general public it might not be appropriate for members of the public to go into prisons and single out individual prisoners for interviews. The opinion contained a couple of ambiguities. Stewart's opinion did. One was, does the case turn on the fact there was quite adequate access to the prisons? Stewart emphasized that. Or did the case turn on the legal ruling that there's no right of access at all? And the second ambiguity has to do with the press. Is the problem here that the press was demanding special access over and above what the general public would have, or again, that neither the press nor the public has any right of access to prisons? And in the process of deciding the case, Justice Stewart had said the press has no greater right of access to government facilities than the general public. Well, that was 1974. About a year later, I got a call from Mel Wax, who was the news director and anchor at KQED, Channel 9 in San Francisco, that then had a daily news program. And they had been following events at the Alameda County Jail, the old Alameda County Jail out in Santa Rita, where conditions had been condemned by a federal judge as cruel and unusual punishment. The locus for most of the problems at Santa Rita was the Greystone part of the jail, the maximum security part of the jail. And a prisoner had committed suicide in the Greystone Park, and a psychiatrist from the jail came on the KQED's news program and said that the conditions there were so awful that they were driving prisoners literally crazy, and attributed the suicide to the bad conditions there. The psychiatrist was fired after his appearance on the program. And Wax told me on the phone that he had just gotten off the phone with Tom Houchins, the then sheriff of Alameda County and the official in charge of the jail. And he had asked Houchins whether he could send a crew out to the jail to film what the jail looked like and to talk to prisoners and then report to the public what was going on in the jail. And Houchins had told him, no way, I have a policy on press access to the jail. It is none. No press access to the jail. I don't allow reporters in for any purpose. And so Wax called me up and he said, can they do that? Completely exclude us from the jail? And I, of course, was familiar with the Pell and Saxby decisions from the year before. And it didn't seem reasonable that a jailer could say no press access at all. So KQED decided to sue. We filed suit in federal court in San Francisco. And conscious of the statement in Pell and Saxby about the press having no greater right of access than the general public, I made the fateful decision to join as plaintiffs in the case two local chapters of the NAACP, the Alameda branch and the Oakland branch of the NAACP, citizens who alleged that they wanted to know what was going on in their taxpayer-supported jail and that they depended on the press to get them the information. It wasn't practical for them to go out and look around themselves. Well, as soon as we filed suit in the case, the sheriff initiated a series of 6 monthly guided tours of the jail facility. 25 people could sign up. All 6 of the monthly tours were completely subscribed the week they were announced, and they included some media people. The first tour took place, ironically, on July the 14th, 1975, Bastille Day. I'm sure the jailer was not conscious of that. And that proceeded, but the judge in San Francisco, Judge Oliver Carter, in the district court, heard evidence from KQED's people about why they wanted to cover this, from, as an expert witness, the sheriff of San Francisco, Richard Hungisto at the time, who had he ran the San Francisco jails and had a completely open policy, invited reporters to come in. Several of them had spent the night in jail and been able to report what was going on there. No security problems at all. Sheriff Houchins took the stand and testified that he was fearful that allowing reporters in on demand would upset jail routine and so on. Didn't really make the case that there was any security problem with allowing reporters in, and emphasized that he was treating the press identically to the way he was treating the public with his newly announced tours. Press and public could go on the tours. They could look at the buildings. The prisoners were hustled out of sight. They didn't get to see any prisoners. And the tours did not go to the Greystone maximum security part of the jail at all. It was sort of an architectural tour, in fact. The judge granted a preliminary injunction requiring the sheriff to allow press access to the jail at reasonable times and places, with the jailer allowed to refuse access if there was some security problem in an individual situation, but that he couldn't have a policy that said you can't come in at all. To my surprise, I thought it was a pretty reasonable accommodation of the interest. To my surprise, Sheriff Houchins appealed to the Ninth Circuit. The appeal was expedited and argued and decided very quickly. The 3 judges all agreed with KQED's position that there was a First Amendment right of access to government facilities, but they couldn't decide on why, and they couldn't decide on whether they should distinguish or follow Pell and Saxby. So they were badly splintered. Still, it seemed like they came out with a reasonable solution. But the sheriff then took the case to the Supreme Court. Justice Rehnquist issued a stay of the order in our favor, and the case went to the Supreme Court. So that's where we are. The court at the time looked quite a bit different from the way they look now. The Chief Justice was Warren Berger, and sort of on the conservative end of the court, you had Rehnquist, who was not Chief Justice yet, was just out of the Nixon administration and was pretty conservative. Harry Blackmun, who had been appointed by Nixon and was relatively new in the court, and Lewis Powell, who was a Nixon appointee, but he had dissented in the Pell and Saxby case, so you can't quite write him off. And then you had Justice Byron White, who was a Kennedy appointee, nominally a Democrat, but was, as we've picked up some hints and will in the rest of the semester, learn that White was pretty anti-press, that he was not a big fan of the press. Then you had Stevens, who was brand new to the court in 1975, had just been appointed by President Ford. He was when Ford succeeded Nixon after the impeachment proceedings, after the resignation. Ford appointed Stevens, who came off the 7th Circuit in Chicago, and he had no track record on the First Amendment, basically, but he had decided a number of cases as a Court of Appeals judge on prisoner cases, prisoners' rights cases, and he indicated in those decisions some sensitivity to constitutional rights for prisoners. So who knows what he would do, but we couldn't write him off. Then we had William Brennan, the architect of the modern First Amendment, author of many important decisions, including New York Times versus Sullivan. We had Thurgood Marshall, the greatest civil rights lawyer of all time, and always skeptical of government justifications for doing whatever it did.